Today we have very special guest, Ido Alexander, who has a wealth of experience in bankruptcy law. So we're going to ask him all of the exciting questions around the various cryptocurrency bankruptcies we're seeing right now. Ido, thank you so much for joining us. Can you give us a little bit of your background?
Thank you very much for inviting me, Sasha, on your podcast. So crypto markets are collapsing and everybody wants to know what and understand what's going to happen next, right? Well, this word bankruptcy is a word that people have been throwing around for the last few weeks, especially as it comes down to the crypto markets. But folks rarely understand, how the process works. And I'm really happy and pleased that you and I had spoken about it, and you've given me the opportunity to try to shed some light on this rarely spoken about world of bankruptcy. So a little bit about myself. I got into bankruptcy law back in 2008, just at the beginning of the collapse of the markets. And that's where I got my experience representing debtors, large and small, in South Florida, including companies that do auto lending or your everyday small guy, anything in between, hundreds of millions of dollars to small time guy that needs to reorganize, and also representing creditors, folks that have to be dealing with the process. If a company collapses, I come in and I try to represent their interest in that. I represent Chapter 7 trustees. Those are the folks that I suspect we may talk about it a little bit just to try to explain to everybody what the type of bankruptcies that are out there. But I represent these Chapter 7 trustees. So I've had a varying experience in the field, and looking at what's happening is certainly fascinating to sit and watch what's happening and understand the dynamics that are going on.
Mm-hmm. Have you ever come up against or worked in conjunction with the firm Kirkland and Ellis? They seem to be really central to the crypto bankruptcy world. They're representing Celsius, Voyager, and now BlockFi. What's your experience with them?
So Kirkland Ellis is one of the largest firms out there, white shoe firm that deals with bankruptcy. And any of the top names you've thought about in the last decades pretty much was them. TWA, Toys R Us, the list goes on. Those are the guys that folks call on to deal with these large cases. I personally have not had any experience with that particular firm. I know folks that have gone to work for them and then ultimately left that firm, but they are the folks to come in and represent large companies in distress and especially situations like what we're seeing now. So it is certainly interesting to watch, especially for somebody like me that came in, grew up in the last 15 years as a bankruptcy attorney, got into the crypto world, and back in 2019 having to represent a fiduciary with respect to recovery of Bitcoin, and all of a sudden got exposed to this world. It's interesting to see this big firm coming in and trying to presumably expand its experience and reputation in this field that's pretty much never been tested out in the United States. There's not been a major bankruptcy collapse of these sorts in the past, and a firm like Kirkland Ellis is very well positioned to address these issues.
Yeah, I think we saw the Mt. Gox collapse in 2014. That bankruptcy case, though, I believe it's happening in Japan, or it's not in the U.S. that I could be wrong on that too, but I don't think it's here. But I just listened to a podcast. Actually, Mark Capellas was on Up Only, so he's the guy that was running the Mt. Gox exchange, and he had a few comments about how his bankruptcy process has gone compared to what might happen here with the FTX bankruptcy. But yeah, it was really interesting. So one thing I've seen all this, like that Celsius was I think Celsius and Voyager, their bankruptcies were, they started a few months before the FTX one, and it's looked like the Kirkland and Ellis bill is somewhere around 4 million a month. Is that, and everyone's screaming like those are our creditor, deposits, that all the money is going to be used up on lawyer fees, and people are worried there's not going to be anything left for the actual people that had money on the exchange. Is that a normal fee to expect from a situation like this, or does it seem a little exorbitant to you?
So, the answer is a little bit more complex, right? Just like everything else in law.
Yeah.
I want to take a step back, and you referenced Mount Gox. Well, so Mount Gox was correctly, you pointed it correctly, it was in Japan. That was really the first collapse that everybody was looking at, but it was under Japanese law, under their proceedings. Here we are in the United States, where there's not been a collapse of that nature with of a crypto firm, and that is in itself setting new precedent and will set new precedent. To understand bankruptcy better, and I think that's why I'm in answering your question, understanding bankruptcy, you need to think of it as a 3D chess game with multitude of constituencies that are appearing in a case. A firm like Kirkland, who's representing the debtor, is stepping in and is needing to deal with a variety of issues. Now, you mentioned the $4 million a month, and that is a lot of money. I don't want to say that it's not a lot of money. It's certainly a substantial amount every month, but it needs to be taken into context. And the context is, when you have cases of this magnitude, when you have a situation where a debtor, and being in the position of debtor's counsel, you're dealing with a multitude of issues, anything from day-to-day operations that you need to address, to preparing all the requisite documentation that's associated with the case, to addressing the concerns and inquiries propounded by third parties, by various creditors and other constituencies, and then litigation and addressing any issues associated with on that end, in terms of addressing any contentious issues that come up along the line. And when you're adding all these factors up, and you are sitting in the debtor's counsel seat, and you have all these various, think of it as various lobbed missiles being lobbed at you from various directions, and you have to continue trucking on, these are substantial sums, but they need to be taken into context. Now, keep in mind, Kirkland is billing New York, Chicago rates. Now, bankruptcy rates, generally speaking, I'll throw numbers, they may be a little bit higher, a little bit lower, but you're looking at the $700 to $1,200 an hour for those types of attorneys that are dealing with this case. Probably a little bit more on some, in some respects, probably a little bit less in some respects. But to give you a sense, here in South Florida, you're talking about rates ranging from the 400s to the 700s. But the folks that are at Kirkland are definitely billing at the higher rates. They're dealing with a multitude of issues. And last and not least, it's important to keep in mind that while they are getting paid this sum, all these amounts that are getting paid are ultimately subject to final approval as part of a fee application that's going to be either done on an interim basis or a final basis, and whereby they're going to have to submit to the court all their time. The court is going to have to review it. The creditors, creditor committee, other creditors, the U.S. trustee, every one of these constituencies in this bankruptcy will have an opportunity to review these fees and ultimately determine whether or not they're reasonable, all within the context of whether or not it benefited the bankruptcy estate. Now, a lot can be said to what can benefit the bankruptcy estate, but it's not that somebody just cut a check to Kirkland Ellis to the tune of $4 or $5 million a month without any kind of oversight and without any kind of adjustment to these sums.
Mm-hmm. Yeah, I'm subscribed to the Celsius docket, and there's new filings almost every couple hours in that case. So yeah, that's certainly, there's lots of work being done. It's just Seems like a lot, but well, it seems like a lot when the company's money is running out. Like BlockFi, they only have 256 million in cash, and they've already spent 5 million, in attorney's fees. So it looks, I guess it brings the question, is Chapter 11 the appropriate kind of bankruptcy for some of these companies, or should they just be freezing the assets? Because with Chapter 11, like, the company's still running, they're still paying employees, etc. So maybe this would be a good time if you could give us like an overview of the various chapters and what your opinion is of where, if Chapter 11 is the right call in these cases.
Sure. So when you're looking at Chapter 11, there's various types of bankruptcies out there. We'll start off from your everyday consumer, everyday person. You have your Chapter 13, which is essentially a payment plan where a person dedicates their disposable income over a period of time. You have a Chapter 7 that is, corporations can also file it, or an individual, and that is a straight up liquidation pursuant to a statutory scheme whereby a trustee, a third party fiduciary, is appointed and now liquidates all the assets, recovers any additional assets, and then disperses it to the various creditors based on the priority scheme. And then you have a Chapter 11, which, yes, they still have to disperse monies based on a priority scheme, but it's a little bit more dynamic. It's dynamic in the sense that the debtor proposes a plan of how they're going to pay their creditors, and it's not necessarily for the purpose of reorganization. This is the key thing I want to make sure that everyone understands, and that is, when you're looking at a Chapter 11 can come in various flavors and shapes and sizes, and that, yes, in the typical sense, it is a reorganization, but you could have a Chapter 11 liquidation, and whereby you're essentially proposing a plan of how you're going to liquidate and otherwise pay creditors, and creditors have an opportunity to influence that plan by voting for or against, trying to lob objections to, and in doing so, trying to push the debtor to reformulate how the plan is going to take place and how the liquidation is going to take place. So Chapter 11, where the debtor or creditors can also provide their own competing plan after a certain period of time, is a form in which parties can influence what the outcome looks like. And when you're looking at a collapse of the order of a company like FTX, like BlockFi, like Celsius, you're looking at a collapse where you don't want to have a sudden, the best analogy is a plane flying. Do you want to have it a sudden fall from the sky, or do you want it to have some kind of a descent onto the ground and some kind of a landing of some kind? It may land, it may not land with wheels, it may not land with all the wings, but it may land somehow, as opposed to a complete crash, which Chapter 7 is very much akin to that. So it's important to keep that in mind.
Mm-hmm. And so what about the criminal charges? We have the examiner, or John Ray, the new CEO at FTX, he's already calling for an examiner. He's making some pretty harsh accusations about the way the books were kept. He said it was the worst record keeping he's ever seen. And we know that he, cleaned up after Enron. So what do you think are the likelihood of criminal charges? And same thing with Celsius. We have an examiner appointed. She's already made an interim report. So yeah, what do you think the outcome will be?
So I'll add on to what you said, John Ray said, which is, I can't rely on the numbers. It was that bad. And the appointment of the examiner is there to, an appointment of an examiner could be any number of reasons for. One, it could be to provide a neutral third body to come in, examine the books, and provide an additional neutral vantage point that's not influenced by anything. In the John Ray example that you gave, the FTX example, I think that is done to provide the million plus customers of FTX who are creditors in the case a better feeling that there's an additional voice out there looking at the books but it could also be a step short of a potential Chapter 11 trustee appointment. Understand that in many instances, an examiner is appointed by the court to first examine, determine the books, whether or not there's any ongoing malfeasance and fraud going on at the present time. And if they believe that if the examiner ultimately comes back with a report that's scathing enough that says that nothing can be trusted here, that's it's a good lead in to the next step, which is a party like the U.S. trustee or other creditors coming in and seeking the appointment of a Chapter 11 trustee. That is, a Chapter 11 trustee will now take on very much a similar role to a Chapter 7 trustee, but in this case, a Chapter 11 trustee would provide a plan of reorganization as essentially a fiduciary that's now taken control of the debtor. Now, you mentioned FTX and SAM, SBF, and the various potential criminal allegation. I think it's important to look at criminal from two vantage points. Criminal allegations. There are the criminal allegations that could be raised by the various bodies that oversee criminal enforcement, right? Criminal enforcement agencies. And there's criminal allegations that are taking place as part of the bankruptcy case, which are then referred to the Department of Justice, and then ultimately a criminal case is opened and pursued outside of the bankruptcy process. So think of bankruptcy as a civil process as opposed to the criminal proceeding that may run parallel to the ongoing case.
So it would be like if the examiner comes in or the trustee says, these books are unreliable, then the DOJ would use that report to start their investigation? Or I thought the examiner was actually a branch of the DOJ or paid for by the Department of Justice?
So the examiner is pursuant to the bankruptcy code, an examiner can be appointed. It's a third party, neutral, paid for by the bankruptcy estate. Okay. And it's there as a third party that's there to look inside the books and records and understand the ongoings of the company and to determine if there is malfeasance, if there is fraud that's ongoing, especially if it's the same management that existed before the bankruptcy. It gives it even more of a reason to come in and investigate any of these allegations that are raised by third-party creditors and other third parties involved in the case, including the U.S. trustee, that may say, hey, we want to look into what's going on here. Now, if it comes out that the examiner report comes out and it's for everybody to see, then obviously law enforcement agencies are looking at these reports, and they could deduce their own next steps and what their own next actions are going to be in their own independent investigation that is unrelated to the bankruptcy case.
I see. And in your experience, have there been a lot of bankruptcies that lead to, criminal, like jail time, basically for the CEOs?
So criminal jail time for the CEOs, that is, you're looking at things like the Madoff collapse, right? It doesn't happen frequently. And again, it's a creature of an independent investigation by law enforcement agencies. If we're talking about criminal liability stemming from the bankruptcy, that's a completely different creature. That is basically saying that somebody criminally abused the bankruptcy process, defrauded the bankruptcy process itself, not before, but during, and otherwise is violated criminal statute associated with the need to be transparent and otherwise truthful and otherwise comply with all requisite rules and regulations associated with the bankruptcy, right? And in those instances, every couple of years you hear of DOJ, U.S. trustee, which is a department within the Department of Justice. It's they will make a referral to the U.S. attorney in their district to investigate on a criminal case, which then they could decide, the law enforcement agencies can decide we will investigate or we will not investigate. But then it's its own case. Okay.
And so in Sam Bankman-Fried's case or FTX's case, what charges do you think are possible here?
So I don't think there will be any bankruptcy type allegations, right? Criminal type charges against him. I think it's all criminal charges stemming from various violations of law that I'm just going to leave that to the criminal attorneys listening or anybody else with that type of experience to speculate what those charges may be. If you want to ask me to speculate, I'll say there's probably a lot of different violations here that he has committed. I will certainly say that from a bankruptcy perspective, not on a criminal basis, but in terms of what he had caused from within the bankruptcy or prior to the bankruptcy, but that will now need to be litigated, are various clawback actions that would have to be sorted out for years to come.
And how do the clawbacks work? So, it's very public that he was, the second largest political donor other than George Soros. Is there any chance that some of those donations are going to get clawed back?
Yes, it's certainly a possibility. There's nothing that says that you can't go after political donations. There are exception defenses if it's, for example, for a charitable organization, right? But then that's certainly something that needs to be looked at who he gave the funds to, who he transferred those monies to. If it's a straight up political organization, it's not a charitable organization, then those monies will likely or can likely be clawed back for that matter.
Only if he gave it in the last year, or can it reach further than a 1 year time frame?
So let's sort through what is a clawback, right? Okay. So a clawback could take various types of types. You have the preference you mentioned, both to an insider or to an outsider creditor. If it's an insider, you can go up to 1 year, go back petition date up to 1 year, and it's presumed that you can go back through and say that the insider could already tell that the entity was already insolvent, and therefore we're going to be able to recover these monies that were otherwise transferred to a creditor, right? So it's money's paid.
Would the real estate in his parents' name, if that was purchased in the last 12 months, that would probably be considered an insider, but a political donation might not be an insider?
So
again,
I think what we need to do is separate them. Okay. Right? You have a preference, and the essence of a preference is a creditor is getting paid while the entity, or in the period leading up to the filing of the bankruptcy, and that creditor is getting paid, meaning somebody who's owed money is receiving money from the debtor in that lead up period. The law says preference is 90 days. If it's just anybody ordinary, if it's an insider, somebody associated with, affiliated with entity and so forth, then you're looking at a year before, but he has to have been owed money. Okay. And the idea there in the use of the word preference is, why should, I'll take you, Sasha, why should Sasha, as a creditor who's owed $100, receive a month before the filing, receive the $100 that she's owed, while Ito remains unpaid and has to stand in line? So she was otherwise preferred, and the law looks at the last 90 days, presumes as an assumption that the entity was insolvent within that 90-day period, which can be rebutted as an argument, obviously. You also have that assumption that within 1 year to an insider, right? But again, it has to be a creditor for that matter. You reference the parents being bestowed, I'll say it, with real property, and then the question comes down to what value did they provide FTX, for that matter, that they were entitled to receive these properties. And that goes into the second type of clawback, which is a fraudulent transfer. So if the entity or the person, or if the debtor for that matter, in this case FTX, transferred money and did not receive reasonably equivalent value for that money, and that could go back based on bankruptcy law up to 2 years from the filing date, and under certain circumstances based on applicable jurisdiction. Here we're dealing with Delaware, that they file these cases. The review will be done pursuant to whatever the state law. You could also go as far back to what the state law in Delaware provides for what a fraudulent transfer is under state law. So you can even go further out beyond the 2 years. In Florida, for example, you can go up to 4 years before the bankruptcy was filed. And then you have a third type, and that is post-petition transfers. It's almost like a strict liability act, meaning you have a petition date and money was transferred the next day. I've had cases like that.
That's what we have here. You know, the Bahamas and the Japanese transfers that were done the day after filing.
Exactly. But the issue there is now you're dealing with also, you raise the Bahamas, and that raises its own issues, right? So you have the debtor money being transferred to the Bahamian authorities and essentially post-petition, but you also have an entity that the Bahamians are essentially under a Bahamian liquidation that says, hey, we want to be seeking recognition under what's called a Chapter 15, right? And this is where the battle is going to be had, right? You have assets that are essentially transferred out to the Bahamas, and now you have potential, we don't know if there are any assets being transferred somewhere in the US, for example, or elsewhere around the world from the Bahamas or elsewhere. So what is the underlying message? We have the FTX case has every types of fraudulent clawback you could think of probably. And this thing is going to go on for years because there's various defenses that could be argued here. I'll throw something as I was thinking about this podcast. I was thinking, you know, look at what is the solvency of the organization? Do you look at the fact that FTX held on technically onto FTT tokens and these various other types of tokens, which allegedly, according to them, it was worth substantial amounts and otherwise established their solvency. So were they solvent or were they not?
Yeah.
So there's going to be issues here that are going to be addressed for years to come. There's jurisdictional issues involved. The jurisdictional part is going to be taking center stage, I think. But I think each party right now is trying to leverage itself in this power struggle so as to come in and try to almost like share, understanding that they need to share and organize and work with each other ultimately, because there's no winner here ultimately, right?
Mm-hmm.
If they each fight each other, they each need to be dependent on each other. One is dependent for information on the other. Both of them are interdependent for information on each other and their own investigation. There's a cross between the various creditors. In one word, a mess. It's just a mess.
I think dumpster fire is what I've seen thrown around.
It is a dumpster fire. You could see it from the pleadings that were filed in the initial days. You could see that to this day, they still can't come up with a creditor list.
Well, I saw the Financial Times put one out the other day, and then Larry Cermak on Twitter made a spreadsheet of it, and it was $5.3 billion of like stocks or completely liquid assets. Some was even in like a nuclear bomb maker company. Another was in a fertility company where they make babies from your skin cells, like just the most bizarre type of investments. But I don't want to say every, but like a huge cross section of the crypto industry, was listed there that they have some kind of stock ownership in those companies. So what's going to happen to those? Like if they have to liquidate all of their stock positions, that's going to put a huge negative, pressure on those companies that is a little bit unfair. So maybe an investment banker could come buy it out, or what do you think will happen with those?
So let's separate what is on the table. On one hand, you have the assets of the bankruptcy estate of FTX and its related entities. That's one bucket, the assets. On the other hand, you have the bucket of liabilities, these various creditors. And there's potential overlap where you're a creditor, also there's an asset in you. And think about it as real dollars on one hand and monopoly bankruptcy dollars on the other hand.
The
right?
FTT token.
Well, when I say bankruptcy dollars, I mean there's the recovery of real dollars that go into the pot of money that ultimately need to be dispersed to creditors who will get a fractional of each dollar that ultimately they were owed. So they're entitled to, they were owed $100. In reality, they're holding on to a claim. That claim is not one for one. That claim is at a fractional bucket, right? And on the other hand, you have the real dollars where, like you said, these conglomerate of various entities that FTX owned or affiliated with or otherwise transferred money to, they're going to have to unwind all of this in a smart way so as to not decrease the value that they otherwise need to liquidate. And that's going to be the challenging part for them that you reference, and that you don't want to do a situation where you're just dumping it on to get the money. You want to be smart about it. So in this, putting forth a plan with potentially what you mentioned, some kind of an investor, a large investor or a conglomerate, like some kind of a aggregate of a couple of investors coming in together, almost like a white knight that will come in and acquire large portions of this, will be very helpful. But to underlie all of this, because of the interconnectedness and because you have various creditors out there, this is going to take years to work through. I suspect they're going to have to do what's called a substantive consolidation, meaning they're going to have to collapse. It's a process based on equity, section 105 of the bankruptcy code, that allows that to the judge, if made the right allegation, to collapse all the entities, essentially all the assets, into one pool, bring all the creditors together, and then start carving out various classes of creditors effectively, right, based on the priority. There's just a lot here to unpack.
Yeah, absolutely. And especially with the complexity of having, 130 companies all set up and with, various jurisdictional structures. And yeah, it's I mean, the Mt. Gox case sounds like it was so much simpler, but it's still a 10-year, and growing time frame, or, almost 10 years. I think it was filed in 2014. So yeah, I think we'd be lucky if we're out of this one in 10 years, it sounds like.
This is going to go on for years. I mean, keep in mind, just to give you a reference, everybody initially, when FTX filed, folks compared it to Madoff, right? Well, there's a lot of differences, but there's some similarities there. Similarities in the sense that, look at the Madoff case. They're still going on determining various types of fraudulent transfers and avoidance actions of various feeder, sub-feeder funds. That thing is going on for well over the decade, or it's been what, 2008? So we're talking about 15 years. This is going to go on for years. And that is why I think we talked about, why is it not a liquidation, a straight up liquidation versus a Chapter 11? You want to be able to bring in the various constituencies into crafting and helping input, and ultimately trying to determine what the plan looks like, and being able to influence what the plan looks like. As part of the bankruptcy process, you have what's called the Unsecured Creditors Committee. That Unsecured Creditors Committee is there. It's a statutory body that's created based on statute, and is created from creditors that are just making up the general unsecured class of creditors. And it's there to they hire their own attorney. It's a committee. They hire their own attorney. They get paid by the bankruptcy estate. And they're there to act as a counterweight to the debtor, to represent the overall interests of all the creditor by the general unsecured creditor body. And the key words here is the general unsecured creditor body. But there's also interesting situations that arise of what happens when your general unsecured creditor body doesn't all look the same.
Yeah.
Right?
Like,
and that's a challenge.
In different countries, is there, I think in the Celsius case, they're saying that they'll be all treated equally, but that was something that came up, our people in different countries needed to be treated differently based on their home jurisdiction rules, or?
Well, there's the element of jurisdiction, but I think it goes even deeper than that. I think it goes to look at, for example, the customers that were the earned customers. Ultimately, the folks that were depositing, they're subject to that. Obviously, that's being litigated as we speak today, and this week in general is being addressed, and we won't know what the decision is immediately, but as to what their term of use and what the implications are. But I'll ask you a question: is that type of customer the same as, shall we say, the guy that provided servers and didn't get paid?
Yeah.
No, right? It's completely different
Mhm.
type of customer, a general unsecured creditor, for that matter.
Mhm.
And that raises questions. Is the committee representative of all the general unsecured creditors? Do you need to form other committees? I was involved in a case years ago in which it was an insurance, life insurance company that was basically buying life insurance policies and having these various investors come in and invest in these life insurance policies. Kind of sad if you think about it, investing in
Yeah.
people's death.
Mhm.
But there were customers around the world. There were clients around the world. I think it was in the thousands, spread in Europe, in Germany, in Spain, in Puerto Rico, elsewhere. And there, while there was a general unsecured creditors committee that was formed, the folks that were on the committee were not representative of the folks that I represented, a group, for example, from Europe. They're completely differently situated. So
Mhm.
myself and a couple other attorneys who had various customers. So like I represented a group of 80, and there was another guy that represented a group of 200 from Puerto Rico. And we grouped together, formed what's called an ad hoc committee.
Okay, yeah, I've seen there's quite a few of those as well going on in these cases.
So the idea there is one person just doesn't have the financial means. Think about it. You said it earlier. The debtor is burning at a rate of $5 million a month.
Yeah.
One person either have to have really big pockets or group together to have an ability to influence what the plan looks like. And in certain instances, an ad hoc committee, an unofficial ad hoc committee, can become official and be recognized. And then if you get the recognition as an ad hoc committee, there are certain instances that the debtor's estate pays for those attorneys. So now it's not, the burden is not on all the people.
Oh, that would be ideal. Yeah.
So
So do you think people are better off in these cases than to try and form, if they have the means to have their own ad hoc committees or their own personal representation versus just being part of the UCC?
I think that if they don't feel, I think the key thing is to look at the UCC and look at the makeup of the UCC and see who's sitting on it. And is it a representative of the pool of people that they believe they're in? If they feel that they're in a pool of people that there's, like, let's just say another 150 people that are similarly situated to them, that is different than what makes up the bulk of the committee, right? Then clearly there's different interests there of who
Yeah.
controls the committee. Now, keep in mind, the committee still has to look out for the general unsecured creditor body as a whole. They have a fiduciary responsibility in that sense. But at the end of the day, it's a committee. It makes decisions as a committee. And if you could find a group of people that are more similarly like you, then you're better able to actually influence what the ultimate plan looks like, object if necessary, and really make an impact to the extent that you believe that you can influence. I was joking to somebody else. This almost calls for some kind of a DAO to be created of creditor,
Oh,
of
yeah.
similarly situated creditors that otherwise then hire, create some kind of a legal structure to then hire an attorney to represent their interest. If somebody wants to think, Web 3.0 version.
Yeah. I wouldn't be surprised with these cases, if some DAOs get involved. With the BlockFi one, the SEC is listed as one of the bigger creditors. Now, that is just, it's the most ironic thing that, the SEC was pretty instrumental in BlockFi's downfall by saying what they were doing was illegal in the US, making them halt the program for new deposits, charging them a fine of 100 million or 50 million by the SEC and 50 million by the various state regulators. And then, I think that whole thing strongly encouraged BlockFi to have to go to FTX and get a loan. And that, I mean, also they were probably, I've heard that they were using, or they made a bad bet with 3AC, and that was maybe more problematic to them than the SEC follow. But either way, they ended up in this situation where when they took the loan from FTX made a counter, or an obligation as part of the loan that they had to hold customer deposits on FTX. Or, when we say on FTX, what does that really mean anymore? It means nothing. They had to give the money to Sam.
Well, if you ask Sam, he'll tell you that FTX US is fully capitalized. Yet by the same token, he also says that the dashboards he was looking at were not quite accurate. And then I don't know who to believe, because then there's also John Ray, who says that the numbers cannot be reliable. But according to Sam, FTX US fully capitalized.
Yeah, which, geez, it seems like if that's the case, that it's fully capitalized, that might be the poster child for the CFTC to come in and say, well, hey, we need to regulate this whole market, because if you're with us, it's going to be fully capitalized. If you're with the rest of the world, it's going to be, that's the problem. But we'll see what happens. It doesn't sound like it was fully capitalized at all.
But it is ironic that the SEC is now a creditor of in the bankruptcy.
Yeah. So back to that issue, will they actually step in line in front of actual, the people of the United States that they're supposed to be protecting and take the 20 million? Or do you think they'll forego is there a way, or is it common for them to say, okay, in this situation, it's not reasonable for us to be taking money out of the pockets of these other, unaccredited investors?
Good question. First of all, I don't believe that they would be a priority. And, looking at what their situation is, looking at straight up at the bankruptcy code and the fact that this was, I believe it, and I could be wrong, I believe it was a civil penalty that was exacted upon them. And therefore, there's nothing in the bankruptcy code from a priority standpoint that would give them some kind of a higher leg up, priority above the other creditors that are there. So then the real question that we're looking at, should the SEC still share pari passu, meaning on a fractional basis, with all the other general unsecured body? I think that's more of a question of yet to be determined. It's more of a policy. Should they, get a piece of the pie, so to speak, to the detriment of others, right? Because if they take money, it's less for others, right? Mm-hmm. Good question. Because we don't know how this thing is, we're only in the early days, and this is the important thing to keep in mind. These cases have only been filed this year. If you're going to look at the overall arch of these types of cases, as we said before, it's going to be years. And typically in situations like this, you either end up having somebody that, if there's anything left value-wise, you sell the assets. The ongoing clawbacks, what ends up happening there is they all get folded, all the cash and all the clawbacks, the value of what they're worth, get folded up into what's called a liquidating trust. It's a creature that sort of lives as part of, you approve a plan that creates a trust, a vehicle that effectively now has all the assets and ultimately distributes to the creditors for years to come as the monies are collected in. And the reason I mention that is nobody really knows how much is out there right now that can be ultimately recovered and ultimately dispersed to the creditors. So nobody really knows what the value is of these claims, how much they're going to be valued. And yes, at some point, the debtor or the creditors or jointly, there'll be a joint plan, or the debtor will propose a plan that will say a likely distribution of X plus any other recoveries that may be had. We're not going to know what those recoveries are going to look like for years to come. And it's important to keep that in mind as we're looking at these cases.
It's interesting too that the value of a lot of these assets are very volatile. So, the Solana bag that they're holding, I don't foresee any of that going up like crazy, but it could, there's nothing, we don't know what 10 or 15 or 20 years that this takes to unfold what the asset value of these instruments are going to be. Like the stock in some of these companies, like could end up saving the day. It's unfortunate that they didn't hold any Bitcoin. Like they just immediately sold all their Bitcoin every time they got it, which, that's what the saving grace in the Mt. Gox case was, because the Bitcoin's value went up, considerably over the last 10 years. So it'll be.
And you touched on something that's also another debate that, again, in bankruptcy discussions and generally, Mt. Gox was in Japan. Yes, they ended up keeping the tokens as part of the ultimate plan, and it appreciated, and ultimately they got a whole lot more than what they initially anticipated. In bankruptcy in general, the idea is always to maximize the benefit of the estate, but you can't risk it. And the danger there is,
Okay.
Right. So then there's a push and pull there. And the push and pull that's going to happen is, yes, a lot of the customers and a lot of the constituencies here are from the crypto community. So in their mindset, it's coming in and saying, you know what, we really believe in the technology. We ultimately believe that these holdings could appreciate, probably will appreciate in price. But the issue comes down to, who wants to take the risk? Everybody's going to cheer for you if this thing goes up in price. But what happens if you approve a plan, or ultimately, forget it, you pushed forward a plan, people fought you, you pushed forward a plan that ultimately resulted in a loss because, well, we kept some crypto. It's the safer route. That's part of the reason why there's a belief out there that if you're holding on to crypto, you got to liquidate. Establish a threshold. Cash in the bank is safer for the benefit of the creditors than crypto, which is highly volatile. And the issue is volatility. If crypto was less volatile, I mean, look, I'm an investor in Bitcoin. I'm sure you are. Yes,
yeah.
we do.
I only invest in Bitcoin. Like I don't invest in any of the other. I have a little tiny bit of Ethereum, but
I have Ethereum as well.
I have all my eggs in one basket, pretty much.
but the question is, you're aware that it is volatile, right?
Mm-hmm.
Right? Would you gamble your kids' education on it? That's a question, right?
Yes,
maybe so, but that's your choice.
But if I were in charge of the bankruptcy, I don't know if I would, because like you said, like the prudent investor rules and all of that, I recognize,
you're acting in a business judgment as a
Mm-hmm.
prudent investor, and you're acting for the benefit of the creditor body as a whole. Now, investing in Bitcoin with its volatility, it could raise its own issues. So, Simon, I forgot his last name. Dixon has said, for example, in the Celsius, let me come in, buy some of these assets, and in exchange, creditors will receive a stake in this entity that is acquiring, and ultimately they could get their money back, right?
Mm-hmm.
Speculative. What are you going to say to the other guys that are just wanting to know that, for example, let's just say right now the markets, I think somebody sent it to me recently, there's a claims markets, right? Markets where creditors can sell their claims, and it's hovering in the 3 to 10 cents on many of these cases, right? What are you going to say to the average general unsecured creditor who now knows that they can get a 3 to 10 cents right now if somebody can pay them? So they know generally that's really what it's worth. Let's just say it's worth 10 cents on the dollar, what they're holding. What are you going to say to him if tomorrow morning this thing goes down to 2? Is that fair?
Yeah,
those are the questions that they're dealing with. But they're dealing with other issues as well. So it's a mess.
Yeah, it is. Yeah. But the time frame, like forcing people to hold, if it was in Bitcoin, which in this case, in FTX's assets are a bunch of trash, it looks like the FTT token's probably never going to come back. The Solana, I mean, it's, I don't know enough about it, but in my, limited opinion, I don't think that coin is gonna do anything after this, like, because it was too close with, with that.
Right.
So, a lot of but the stocks in various crypto companies, the equity positions, those over a 10 or 15-year period could very well go up considerably and end up saving people. So maybe they should, but a lot of them are not public stock, it's private companies, and it's just going to be
How are
hard
you going to,
for
there's
someone
a
to pass
multitude of
those.
issues there when you're
Yeah.
thinking about it. And think about it, it's startup. Look at the average. I don't know what the percentage is, but everybody likes to say it's crypto. And yes, listen, it is the crypto is a representation of blockchain technology, and it is the future. There's no doubt about it, with large entrants into the market. But at the end of the day, these are all startups, no different than the heydays of the .com.
Yeah.
How many of those
Yeah.
survived?
I think that's a really good analogy. Yeah.
It-
Well, so what what would your final words of advice for people who, we're kind of playing light about some of it, or I have been speaking lightly about it, but the reality is there's a lot of people harmed by this, these bankruptcies, and what do you advise them to do?
Well, this is not lawyer advice. Put all the disclaimer.
Sure, yeah.
Look, follow these cases closely. If you were affected and otherwise impacted by them, follow them. Don't ignore it. These are going to be here for years to come. I actually maintain a Twitter account that I routinely comment on. I also maintain a LinkedIn and a Telegram account. It's Telegram is @Crypto Bankruptcy News. So if you're interested in follow that channel. And
yeah, that channel, I've only been in it for, I think a week and a half now, but that's been my main source of truth for these bankruptcy cases. So I appreciate that you added me in there.
thank you. And what I do is I typically post on LinkedIn, and I'll post the pleadings. I treat this as sort of looking under the hood of bankruptcy and trying to extract quick information for folks to understand what's going on, what's the dynamic that's happening in these bankruptcy cases. But in short, folks should understand what's happening in these bankruptcy cases, act accordingly in concert with other people. So to the extent that you wish to influence, group together with other folks and get representation that otherwise goes into these cases and makes your voice heard. And last and not least, I'll repeat what's been repeated to me throughout your podcasts and other podcasts. Not your keys, not your crypto, right? It's critical to understand right now. There's just, because of the lack of framework, that is just, there's no framework that provides these large exchanges a framework and otherwise security for the everyday depositor. And unfortunately, folks thought, hey, I'm going to deposit my money, get my 8-10 cents on the dollar, and somehow, preserve my wealth in the onslaught of ever increasing inflationary percentage points with every month. And in reality, there's no free money. And because of that, and because of the uncertainty, it's important to keep in mind, if you're going to invest in crypto, not your keys, not your crypto. Follow these bankruptcies closely, where bankruptcy is really an I call it the underdog of law, right? Everybody always likes to talk about criminal law. Everybody always likes to talk about securities and various types of other law. Bankruptcy, to me, that's what attracted me to bankruptcy, is that it's not only is it a 3D chess game, it involves pretty much every single area of law or facet of life. In my career, I've learned about aviation law, anything from airworthiness certificates to how to lend. How does lending to how does the auto lending industry work, and anything and everything in between. It's because bankruptcy law touches every single aspect of life. So I really encourage you to follow Bankruptcy, follow specifically crypto bankruptcy news, because it presents a whole host of issues, from privacy to securities to contract to you name it.
Ido, if someone has lost money on any of these crypto bankruptcy exchanges, are you someone that can personally help them or represent them?
Yes, absolutely. I can help anybody from the guy that lost $150,000 to a company that is dealing with their own involvement in the case, whether they are a creditor or a vendor, in that sense, whether they're potentially subject to a clawback. I can certainly try to help and be there for them. I've been there before on the side of the anybody from a corporation to an individual who's dealing with this. Keep in mind, the more, the merrier. Similarly situated, the better, because then you could share costs as well. So it's important to keep that in mind if you can aggregate folks.
Well, thank you so much, Ido. This has been absolutely enlightening for me. Hopefully everyone listening, has learned a lot as well. So I really appreciate your time. Thank you.
Thank you. And thank you very much for the opportunity.